good afternoon. Thank you for joining us. Good morning or afternoon, everyone. Thank you for joining us online. My name is Lorraine, one half of the founding team at Elaine Law Group. I want to go ahead and introduce my law partner, Elon, who is the trademark guru. Elon, if you want to go ahead and introduce yourself.
All right, I'm Elon Moore Jones. I mostly do the work with the trademarks and office actions in the office here at the Elaine Law Group. So,
Wonderful, wonderful. Well, thank you so much again, Elon, and we're ready to go ahead and get started. We have some people who have joined us on the Zoom, and so of course they'll get priority in answering questions. You can also submit your questions online by commenting on the video. So let's go ahead and get started.
all right, so we're going to go over kind of some of the basics of trademark in the beginning. We do have a trademark 101 video on our YouTube. And our YouTube channel is basically you would search Elaine Law Group and you'll see our trademark one-on-one video. We're going to go over this briefly because we want to get into like some of the more complex issues that you might encounter with trademarks. But before I begin speaking, I would like to give the disclaimer that enjoying and listening to this webinar does not create an attorney-client relationship, and this is for informational purposes only. We are Texas attorneys, and we are able to practice before the United States Patent and Trademark Office by way of our Texas licenses. So if you have any in-depth questions, maybe about something that you're experiencing now, we encourage you to book a consultation, and we'll show a video at the end on how to book consultations with our law firm. So now that that's out of the way, the basics of trademarks, like what is a trademark, right? The general overview is essentially a trademark allows you, the owner of that particular mark, the right to enforce nationally and in some cases internationally, the rights to have and hold the actual ability to enforce a registered trademark. A registered trademark through the United States is issued by the United States Patent and Trademark Office. And trademarks are specifically for brand identification, not to be confused with copyrights or patents. Copyright is more so for the tangible medium in which things are captured in, like books, videos, etc. And patents are for like processes, procedures, new innovations or inventions, even pharmaceutical recipes. So patents are for like the actual things themselves. Copyrights are the things fixed in a actual fixed medium, whereas a trademark identifies your brand identity and protects your brand identity itself. So we want to think logos, um, even slogans or catchphrases or terms that are always incorporated with your trademarking and branding. So that's in a nutshell what a trademark is. Why is it essential for your business branding? Well, like I said, it gives you the opportunity to actually enforce those rights. Just putting it out there in the universe is not enough. Just to say, oh, I was here first and I did it. I did it first. Nobody else should be able to copy me. Or I did a poor man's trademark, meaning like you mailed it out to yourself. That's not enough. Um, in order for it to be enforceable, it has to be registered somewhere. And in the United States, we're first to file. And so for those who beat you to the punch, maybe for something that you think you've been doing for over 5 or 10 years, if they've registered before you, you have to go through a real fight if you want to get them to, either relinquish or not be considered for the trademark in itself. that is an oversimplification of the process. But like I said, we have a one-on-one that kind of delves a lot more deeply into actual trademarks on our YouTube video. And we can definitely talk more and more in depth about how to get from the very infancy in the very beginning of the trademark process and navigate you through it. But what we really want to delve deeply into today are more so our office actions, which is what you are likely to receive if you're doing the trademark on your own, or even with an attorney's guidance. Sometimes you can receive an office action, and the office actions are responses from the trademark office after it's an official letter sent to the client or the applicant officially from the trademark office, identifying any legal problems with your application or your chosen trademark. But before I delve into that, are there any questions about the basics of trademarks before we go into the deep, deep dive into office actions? Okay. So again, an office action is an official letter sent from the United States Patent and Trademark Office. You receive that after the initial application has been reviewed, if there's a legal question or a problem with your chosen trademark. Some of the most common office actions are likelihood of confusion, or merely descriptive, or geographic reference for the trademark. But the office action itself gives you an opportunity to get one more bite at the apple and gives you a chance to respond in a timely fashion, which is now 3 months. You believe we actually used to have 6 months to respond to office actions, but it's now 3 months. So Lorraine, I'll let you take it away with your I know you have some questions. I won't just keep babbling on and on, but that's just kind of the brief overview of office actions. It is very important, though, also to make sure that you respond in a timely fashion within that first 3 months.
Absolutely. Thank you, Elon. I do have a few questions. And so let me get right to those. The first question I have is you've briefly talked about, what they are and the common types and the timeline. Can you tell us what happens if you don't respond on time to an office action?
Yeah, so office actions come in two different ways. One is considered a non-final office action, which is the initial, maybe one or two correspondences from the trademark office. And it will literally say non-final, right? Meaning it's giving you a genuine opportunity to respond within that 3 month time frame. Then they may send another non-final office action if you miss that deadline. But the risk that you run, the main risk that you run in not responding to office action is abandonment of the application. So after you've spent all this money, all this time and effort into submitting your trademark application, submitting the best trademark application that you possibly could have initially, and ignoring an office action would not be wise. You want to make sure that you're responding in a timely fashion within that first 3 months to make sure that the examining attorney, one, knows that you're still interested in this trademark, because they'll allow it to abandon if they receive absolutely no response from you, because it's like, hey, we're waiting on you. You don't respond. We assume that you're okay with allowing us to drop this application. And then, you run the risk of losing the complete application itself. Then once you fail to respond, you'll receive what's called a final office action. And that final office action will be determination of whether or not you're going to actually abandon.
Thank you. So that's very,
Hey,
oh, go ahead.
it said my connection was unstable. Sorry. I guess I'm catching up. Okay. Can y'all hear me okay?
Yes.
Okay. Um, sorry, forgot where I was. I believe I was just talking about how they give you an opportunity to give maybe reasons why you failed to respond to that office action. If you don't provide any reasoning, then it's gonna likely abandon very soon thereafter.
Thank you. Are there fees associated with responding to office actions?
Sometimes you can run into a fee, right? So, some fees that are associated might include, if you need to change the application from a 1A application, which is actual use, to a 1B application, which is intent to use, and you do that if you don't have specimens that are sufficient at the time and that were actually being used at the time of application, you'll incur a fee to then change it back to a 1A. So it's like you filed as a 1A, you didn't really have the specimens that were required to show that you're in actual use. So then you change it to a 1B as a strategy to maintain and keep that trademark alive. But in order to now then file the new specimens showing that you're actually using and claiming actual use, you then have to pay a new fee. I think it's 125. The fees are going up very soon. Um, you do incur a fee there. Sometimes you can also incur a fee if the examining attorney finds that there was a classification that you should have included to better capture what you're actually using the mark for, and you have to pay for that additional classification. That's very rare, but sometimes people submit a type of application that it's a T's plus and a T standard application. Sometimes people submit the T standard application thinking that they're gonna kind of give this overall holistic approach of what they do, and they pay one fee, but in actuality it's like three fees that they should have paid, because that holistic definition of what they're thinking that they do, and this happens a lot with pro se applicants, people who are filing on their own without attorney advisement. um, they end up having to break that little whole holistic view of their description down into its component parts. And then you have to be charged an additional $350 for each classification.
So it sounds like we need to be on top of things. Thank you, Elon. I have a few more questions here. Um, can you explain some of the substantive refusals, such as likelihood of confusion or merely descriptive, and how you've addressed these?
Yeah, most definitely. So, like I said, likelihood of confusion is the most common refusal. Like, it is the reason why most applicants do not get past the initial phase. And that happens when people probably didn't conduct a thorough search. They're like, oh, I went to Google and I didn't see my brand on Google, so it should be good enough for the trademark office. But that's not the standard. The standard for likelihood of confusion is just literally breaking it down. Like I'm gonna make this like very elementary. Likelihood of confusion is literally like, is there a possibility that it can be confused with another existing mark, or a prior registered mark, or even a pending registered mark, like one that might be pending in the queue? Every single day, people are filing new applications. So sometimes those are not flagged in your maybe initial research that you might have done. You you could be simultaneously filing at a time when someone over in we're in Texas, so somebody in New York probably has the same genius idea as you, and um they have filed during the same or a day or two before you. Well, that application, if it's the same thing, the examining attorney is going to send what's called an advisory refusal or advisory to the likelihood of confusion, and that can happen. So what is likelihood of confusion? It could be confused off of sound. It could be confused based off of like the literal translation of something or words. It could be confused um, based off of one or two major words within a larger mark. Um, so for instance, one of our callers is Dragon King, right? I'm just using it as an example, not saying that this is your mark. But if there were a Dragon King pending registration for an applicant and there was an already existing Dragon King 2, that is a registered mark, right? Just adding the letter, the number 2, or adding the word the or the word a Dragon King is not enough to distinguish one Dragon King from the other. And the basic standard there is the impression that these marks create upon the actual consumer of those products. Not the impression that it created on you, not the impression that it created on your attorney, but the potential consumers of these. Could the consumers likely be confused when they're going into the marketplace looking for something similar, right? Similar in classification or closely related in classification as yours, and they're all named Dragon King. One is Dragon King 2, one is a Dragon King, one is the Dragon King. Could that possibly confuse consumers? And arguably, yes. Okay, because the main or the primary term is Dragon King. Okay, whether it has a 2 or a or the in front of it, my mind is going to say this is all from the Dragon King. So that's likelihood of confusion. And it gets very fairly and ironically, it gets very confusing for applicants that are pro se, that have not had an opportunity to ever review or understand what the examining attorney is actually looking for. So they might send you an advisory associated with that office action. And that advisory would be to hire a trademark attorney. I see some things
Yeah,
over
we do have some
that.
questions in the chat. I want to get through some of these office action questions first, and then we will definitely have time for Q&A and answer your questions. So if you can hang in with us, we will definitely get to your questions. Thank you so much. So a little bit more on office actions. You know, things like missing information or improper specimen. How do you overcome those?
Can you repeat that question, Lauren? Sorry.
Yeah, no problem. So, with other issues such as missing information or improper specimen, how are those addressed?
Yeah, so sometimes I guess what you might be referring to with missing information might be sometimes entity um identification is unclear. A person might be filing as filing and wanting the ownership of the trademark to be in their company name, but they put their name as a person, and then they put that they're an LLC, but a person's not an LLC, so we need clarification submitted to the examining attorney, and that clarification will come in the form of, no, actually, this is the company name. It is a Texas entity, and it is in fact an LLC, not Lorraine Bearable LLC. So that can kind of be missing information. Another thing missing information could also be a failure to actually define a term that they may consider to be another from another language. Um, I can't like give you specifics from clients, but let's say Sarah, like, oh, que sera, sera, right? We know Sarah is like it will be, right? In Spanish, right? But um your mom might have named you Sarah and you thought it didn't mean anything. And it's a part of your brand identity. Maybe you have Sarah Spa and Wellness Clinic or something like that, right? That might be a good idea. But anyway, you might have Sarah's spa, wellness, health, whatever. But you thought it didn't mean anything, but the examining attorney has this, infinite knowledge base at their disposal. And they're like, no, Sarah actually is defined, so they might be asking you to give or provide a definition for a term. Also, you could have missing information, which could also include a likeness or of a person. Um, if that person is living or deceased or whatever, they have to give consent, or their estate has to give consent, or if they're a minor, the parent has to give consent to actually trademark and make a registered trademark of that person's name. Or if it's your name that you're trying to, register, you have to provide consent. So those are some examples of missing things. And what was the other one, Lorraine?
Improper specimen. I know that's a common one.
Oh, yeah. Yeah. So specimens must show a correlation between the actual mark that you're registering for and the actual use in commerce in order for it to be a viable specimen, meaning that it's a brochure showing prices for consumers to purchase. It could be your website showing a point of sale, but everything has to have that correlation between the brand identity, the brand identification, as well as a way or means to pay for it, or an intention to pay, to receive uh, the dollar bill, the greenback from the customer. It is literally the only way that the USPTO has jurisdiction over all 50 states, right? The USPTO is a federal entity, and in order to go into states and, kind of dictate that all states have equal trademark rights, they have to have something called the Commerce Clause. Some of us learned that in history. And in order to show that there's a stream of commerce between, or a potential stream of commerce between state lines. And that's the only way that they're able to show enforceability. So you have to show that as an applicant, you are actually in the stream of commerce.
Gotcha. That makes a lot of sense. And it's very common, and we get questions about it all the time. So I wanted to be sure to bring that up. Can you talk?
I'm sorry, Lorraine, specimens can also be unclear. Like if you submitted a bad picture, bad image, um, or if you submitted something that just absolutely doesn't have the mark on it anywhere. So another one. Sorry, Lorraine. Go ahead.
No, you're good. So another one that I think is important to address is disclaimers or modifications for office actions. Can you talk a little bit about that in the goods and services description?
Yeah. So when a disclaimer is required, it's usually required for the most common terms, maybe within that industry, or some of the most common terms in general vernacular. Um, but a disclaimer is literally saying, I'm disclaiming these words um, as used, you know, in association with this mark, but I'm only having ownership in the word as it is used at this time with my mark. For example, if we wanted to have a registration for the Elaine Law Group for law firms, for law firms, for legal services, for all things related to legal, we would more than likely have to disclaim the word law and the word group because they are some of the most common terms used in law firms.
So that
Got it?
makes sense.
Hope that makes sense.
That's a great example. Thank you so much. So now I want to kind of get into some of the things that people can do to reduce the risk of office actions, because it sounds like something that people don't want is an office action, because it just, ideally, right, you don't have those. And so if you can talk to us a bit about how we can reduce our risk in that and the role that research and clearance play in avoiding office actions.
Yeah. Sometimes office actions are unavoidable. Like I said, you can have somebody that's simultaneously submitting the application at the same time as you. You had no idea, even through all the research that was submitted or done, the due diligence searches that might have been done initially. You just can't predict what somebody on the other side of the world could possibly be applying for. It's impossible. So even your attorney's due diligence, the research, we do what's called clearance searches. Clearance searches are very important in giving you a applicant an overview of what's already within the database, right? And in the common law, our clearance searches include common law. We can also expand those clearance searches to include international searches as well. Um, but they are a snapshot in time. So, although that is to me your most effective and your most thorough way of going about determining whether or not one, your mark is good enough. Two, there won't be a likelihood of confusion, refusal, or there won't likely be a likelihood of confusion, refusal, provided that red herring, there's somebody that could always apply. And having an attorney's eyes on what you're submitting. So as attorneys, we want to reduce the likeliness of you receiving an office action by examining your specimens closely, see if they'll pass muster. We review the comprehensive overview and research that we pull to determine whether or not there are any red flags there, mostly for likelihood of confusion. We also determine whether or not your mark is merely descriptive of what you're doing. So when a mark absolutely describes verbatim what you're doing, it's not sufficient. Or if a mark is just merely ornamental meaning something's just plastered across like Lorraine's sweater. It's literally just plastered across a actual t-shirt. We couldn't then go file and say we're now in the business of selling hoodies because it's merely ornamental. It's not functioning as a brand. Functioning as a brand or a brand identifier would be something small like the logo. You want to think Ralph Lauren. You want to think tags in the back of shirts. So I think you can see my tag. You want to think tags in the back of shirts. Um, Branding on waters. Um, Not sponsored, but brandings on water or maybe your stamps on your things, right? Those small inconspicuous things that still show that, hey, this was created by the source of this thing was by X, Y, and Z company. Those are the types of things that actually show and are actually functioning as brand identifiers.
Thank you. That was a wonderful explanation there.
I hope it
So
was.
You really kind of brought it to life there. So another question that I have is, can you talk, and you did speak a bit about this, but just a little bit more, the advantages that clients have in working with an experienced trademark attorney as a compared to going on, some sort of company online that says they do trademarks at cut rate, but you also get cut rate service when that office action comes.
Yeah, I think you kind of summed it up there. Yeah, so the difference between an actual boutique firm like ours, Elaine Law Group, and these larger kind of trademark mills, um, is that they'll have maybe one or two attorneys on the actual team, and the rest of the people that look at your applications, even if they even look at them. But a lot of these trademark engines or trademark mills are literally just databases, kind of they pull all the information that you submit in your intake form, right? They're not reviewing it for corrections or misstatements of facts. They're not reviewing the specimens. They're also not reviewing whether or not you even attested to appropriately, et cetera, et cetera. They're literally just compiling your information and then sending it out to the PTO for filing. Is it cheap? Yeah. Is it quick? Yeah, it is. It's quick. But is it the best use of your money? Is it the best use of your time? Probably not, unless you're like really, really well versed on trademarks, right? Because they usually don't have an attorney reviewing them or don't even have eyes on them at all for that matter, to give you some real insight. So I know some sites sometimes you can pay for an attorney review or what have you, but um with us or a boutique firm like Elaine Law Group, we are literally taking your application from start to finish. We're reviewing your specimens closely. We might even send it back to you a couple of times, like, this is not good enough. This is not what we, this is not going to help us. We need you to do X, Y, and Z. We tell you and show you like examples. We walk our clients through step by step of what really, really we have seen as the most successful applications. We also do the full and thorough review of the actual comprehensive reviews to show you where your mark, as brilliant as it may have been, is already in the trademark database so that you're not wasting your time, money, or energy, or continued energy behind something that we know you're not going to be able to protect.
Thank you, because that is a common thing we get calls about all the time. And so I want to make sure we explain that to the people out there on Facebook and those that have joined us in the Zoom. And so just a couple final questions I have before we open it up to questions from the community. And this is an opportunity. I'm going to just take a second, a personal privilege to brag on my law partner. I call her the trademark guru for a reason. I have wood on this desk and I am knocking on it. But for people who start their application with us, we have a tremendous success rate. And I think that has a lot to do with the due diligence, frankly, that Elon and our team puts in just to make sure that your application is best positioned at the time of application, right? Because we want to minimize in advance. We want to foresee as much as humanly possible what objections the U.S. Patent and Trademark Office might have so that we're prepared on the back end. And the representation process can take over a year. And so, but we are, obviously diligently working on your file that entire time to hopefully get you an approval. And so I just want to take a second and privilege to give some kudos to my partner, because she is that guru, she is that girl. And so if you could share some success stories, Elon, of some challenging office actions that you've helped to resolve.
Yeah, sure. Sometimes we have had clients come to us to resolve their office actions that we did not take from, like, we didn't start their application, but now they're having issues on the back end, right? And so for those, for some of those clients, what we've seen, and one of the some of the more particular ones that we've seen, may even require you just going from the principal registry to the supplemental registry, and that can help resolve a lot of issues. That happens a lot of time when something is in use, you're actually been using it, you've been committed to the mark consistently for however many years, but it's still kind of merely descriptive of what you're doing. A way to get past that is when it's offered to the client from the examining attorney would be to amend to the supplemental registry. Supplemental registry still gives you all the same rights of enforcement. You still get a registration, which is, the golden ticket in the end, right? I've got a golden ticket. That's what you need, right? And that can definitely help you bypass a lot of issues. So as far as success rates in that, sometimes the supplemental registry is kind of the better route for clients to go, instead of trying to, like, some clients want to argue and want to pursue it all the way up through the Trademark Trial and Appeal Board. But I will say, in a lot of cases, for most of our clients that are small businesses, founder-led businesses, it's not, it doesn't make most financial sense, because arguing before the T-Tab can be expensive. So we try to help our clients save money, all while still achieving their ultimate goal, which is to receive the registration.
Okay, and I would just again take another moment of personal privilege to add that the vast majority of office actions that our team has handled with Elon leading us, we have been able to overcome. Most certainly not all of them, but we have a pretty good success track record. Again, because we do the due diligence. If we end up supporting after the application is submitted, we do our best to try to right the ship as much as possible. And sometimes after evaluating it, it might make some more sense and give the client more rights if they just do a new application with us. And so, by scheduling a consultation, that is how you can learn how your brand is positioned to get that specific questions answered you need for your particular business. Every business and their situation is different. So at this point, I do want to go ahead and transition it to questions for our audience. So I'm going to go ahead and put up our Q&A screen here, so everyone knows that it is that time. And this is the moment, the doors of the church are open, so to speak. And it's time to go ahead and put your questions in if you haven't already. And let's go ahead and start answering some of the questions that have already come in, Elon. We have one person on Facebook who asked, I have started a media company in the social media space. Exclamation point. What can your firm offer for image, copyright protection, etc.? And I'm sure there'll be trademark somewhere in that mix. Elon, if you can answer that for us.
Yeah, so depending upon, like, what you mean by the space, because that can be quite a few different things. We have represented, and we still do represent, social media influencers. The influencer space is one thing. E-commerce space is another thing. So depending on what we're talking about, space-wise. We could be talking about your brand. We could be talking about name, image, and likeness. And we can also just be talking about maybe a product or a service that you're providing that is unique, that might need some additional brand protection. But of that, usually what we've seen in social media led businesses is that there's sometimes an identifiable brand, meaning that maybe this is social media marketing by name, right? And you want to then trademark your brand, which is social media marketing by name. As long as that is consistently used, that brand identifier is consistently used throughout everything that you're doing, we'll have enough specimens to submit and to support an application for a review. And it will be in that social media space. Sometimes it might be branding or marketing of other brand items. So we have some clients that'll be like, you know, go, drink water. And their moniker is above them in the image in the picture. That's our way to get the specimens. But it's showing that they are advertising products of another company. Um, Also, sometimes people are lifestyle brands. Although lifestyle is very vague and it doesn't really mean anything, but we help our clients to parse out and break down exactly what that means for them. Are you doing health and wellness for families? Are you doing transition wellness for new mothers, et cetera, et cetera? Because so those things kind of end up being in that little catchphrase of lifestyle and imaging, and we're like, that's not a real thing. We have to break it down into its component parts. So hope that helps. But yeah, it could be your image, your copyright. What we also offer, thanks to our guru, our contract guru, Lorraine, are some of those contractual obligations that you may enter into. And we review those contracts for your best protection, negotiate those contracts on your behalf, and also insulate your intellectual property rights in those contracts. As far as you want to maintain them. And so we offer contract review. Copyright protection, we definitely offer copyright protection to clients through the Copyright Office, which is totally separate and apart. Like we said in the beginning, it's a different thing. It's different from trademarks, but we certainly try to give a full wraparound service to clients. So if you're interested, we're going to show you that video on how to book a consultation towards the end of this webinar. You can book your consultation. You're on mute.
Sorry. Thank you so much, Elon. Another question that came in from social media, first time viewer here. If you are, update from that previous question that we'd had. They mentioned that that they have an information brand. So anything you want to add to your comments, if it's an information brand?
I don't know what an information brand means.
Uh, I, I,
Mm,
I'm assuming this because I haven't talked to the person, but I assume that they mean more so of uh, maybe like news and information, perhaps, or current events. I'm not sure. I'm just kind of putting that out there.
like a blog or something,
Perhaps, yeah.
or online blog, video blog, non-downloadable.
I'm not quite sure. We haven't had that consultation opportunity yet, but that could be the case. And I would also just kind of, if you could briefly piggyback on this too with podcasts, because sometimes a lot of people in the information space are using podcasts to get information out too.
Yeah. So as far as trademark goes, again, as long as it's branded, we can usually get those specimens enough to get the branding registered and protected. Um, the copywriting itself, you might want to copyright the show or the production style, or even if there's like what is it like a show jingle or something. You can also trademark sounds too. So the best thing I think about is like the Netflix da-dum. It's literally a registered trademark. Um, so maybe those types of things could be trademarked. Then anything in the fixed medium could be copywritten. So if you have some videos that are going live streamed to an archival place where it's captured and stays there, those types of things could be copywritten.
Got it. Thank you so much. And then I think we have one last question that we have here. First time viewer, if you're using a phrase, I think they're talking about a slogan within your presentations, what is the trademark process?
Well, the slogans have to be consistently used for a consistent reason or application or service, right? If it is consistently used, maybe it's also printed on the website, or constantly audio, you have a constant audio trail of those things being used, for what is it? What kind of business is this? We don't know. I'm gonna say that this is like Nike. Let's go with Nike. Just do it, right? Just do it is on absolutely everything that Nike has. T-shirts, shoes, etc. It is printed. It is their slogan. There's no doubt about it. So you want to go as consistent as you see Nike going with just do it. Those types of things are shows the actual use in commerce. It's associated with something that's being sold in commerce, and it's mostly just the consistency. Like don't switch it up, right? If just do it is your slogan, just do it needs to be your slogan all the time.
And just
Not
quick interjection here. She just responded and said that it's a virtual assistant business that provides suggestions.
okay. Yeah, so just using your slogan consistently, not changing it up, but having those opportunities to capture what the actual slogan is. It should be able to be used as a specimen for trademarking purposes. And I'm talking trademarking.
Absolutely. So I think we're good on questions. I'm going to play a short video for everybody. Hopefully the sound works. If not, we will definitely post the video in the comment section so that people can know how to book some time with Elon or anyone on our trademark team. And so I'm going to go ahead and cue that up for us. And they said thank you. So thank you, Elon. I'm passing the message along.
Visit www.elainelawgroup.com or click on the link in our Instagram bio. Scroll down on the website till you see the Schedule a Consultation button and click on it. Fill the contact form accurately. Tell us more about your legal issues and goals so we can know how to serve you best. Tell us how you heard about us. You can select one or multiple options. Select the services you are interested in. One or multiple options can be selected. Click on the submit button and you'll be taken to another page where you can book your preferred time and date. Select the date and time when you'll be available. Fill in your billing details and congratulations. You have successfully booked a consultation with Elaine Law Group. We are excited to tackle your legal issues together with you.
All right. And so we will get that posted as well. So you have the link to know exactly what you would need to do to schedule one-on-one time with us to really delve deeply into your particular trademark issue and get the answers you need so that you can move forward as an entrepreneur or creative professional with confidence. So want to, just take this time to thank everybody. I'm going to flash up our contact information so that you know how to find us. Here we go. And so you can see here our contact information, our phone numbers. We have both a Dallas and a Houston office. You have our email address that's monitored. Our website, obviously, which is where you would go to book your consultation. And of course, follow us on social media for more informative information so that you can move forward with confidence as a business owner to grow and scale your work. Thank you so much for attending.
Thank you, everyone.
Thank you, everyone. Bye-bye.